Good afternoon and welcome to the Appellate Division First Department. This is my first sit since the summer break, so welcome. I want to inform you that we have more than 6.5 hours of argument time requested. So I'm going to ask everyone to please ask for the time you need, not the time you want, understanding that the clock is for you, not for the court. So even if I cut your time by half, if the members of my court still have questions, I let the questions roll, so you may end up with the time you asked for in the first place. Okay? All right. People versus Christian Jacero. Okay. 5 and 1 and 5. KD-1 Doe versus MC Doe. Submit. D. Shaniska versus Gage D is submitted. People versus Travis Glasgow. Submitted. People versus Ruben Flores. Submitted. 21st Mortgage Corp versus Lynn and Renaissance. Okay. All right, it seems you've scared off your opponent. So would you like to readjust your time request?
I'm sorry.
Do you want to readjust your time request since you have no one to argue against?
Yes, 2 minutes, please.
Thank you.
Thank you, Your Honor.
Thank you so much. Brewster versus Hunter.
Good afternoon, Calderon, 6 and 2.
Okay.
Good afternoon. Respondent asked for 5 minutes.
6 and 2 and 5. Yang versus Griffin. Submit. People versus Augusto Scott. Submit. People versus Jatis Leak. We're on a roll here. Submit. Apex Funding versus Blue Earth Resources. Submit. C. Damien versus Melissa S. Okay, thank you. People versus Dantrell Calderon. Okay. Okay, we think there's more issues than what you've requested, so I'm gonna do 6 and 2 and 6. Zane versus Isacson. Okay. Okay, let's do 5 and 2 and 5. Johnson versus Northeast Agencies. Thank you. Stikeman, Elliot LLP versus OL Private Counsel. Good afternoon. Okay. 3 and 1 and 3. Samsung Electronics versus MPEG LA. Good afternoon. Okay. 7 and 2 and 7. People versus Jose Alvarado. Submit. People versus Alfred McCrae.
Appellate request 3 and 2.
Okay. 3 and 2 and 4. Vorham versus Hicks Vorham is a submit. Barger versus Malcolm is a submit. And Nurez versus Morton is a submit. First case on the calendar, People versus... That doesn't get argued. Please come up.
Your Honor, with respect to Nurez versus Morton,
Oh.
I represent the intervener. The appeal was not perfected on the docket.
I received a request for argument and I declined that request, sir.
It's not a question, Your Honor. Just an information that I'm going to bring a motion tomorrow to ask that either the appeal be...
This is an inappropriate application. This is inappropriate. You do your applications through the clerk's office, sir. This is my appellate calendar, and you, sir, are not on it. Okay, so please, I'm sure someone from the clerk's office advised you of that, and you clearly did not follow their instruction. So you can do that after the call of this calendar. That is the completion of my calendar. Now the first case on the calendar is People versus Christian Jacero. Sir, you can go now if you want to address whatever issue it is in the clerk's office.
I'm here already, I'm close to an argument.
Huh? There will be no argument on your case. Oh, okay. You're certainly welcome to stay and watch then. Good afternoon, ladies.
Good afternoon, Your Honors. Catherine Pecor with the Legal Aid Society on behalf of Mr. Jacero. Mr. Jacero's trial involves essentially the entire catalog of factors that this court and the other appellate division departments have cited as supporting reversal based on weight of the evidence. We have two complainants who were literally falling down drunk, lied about it at the hospital and at trial. Their testimony was incoherent, implausible, and riddled with unresolved contradictions.
And all of that was before the jury, correct?
I think so, and you know, we can infer quite a bit about the way deliberations played out in this case. I mean, the jury did acquit on 4 of the 6 charges.
Okay.
And if you look at, you know, they deliberated quite carefully for 3 full days. They asked for readbacks. I think they were carefully scrutinizing the testimony on the crimes of conviction.
There were civilian witnesses that you're referring to in their testimony. Were there any other witnesses, eyewitnesses to this assault?
Sure, so the only other eyewitness to the crimes of conviction, the assault against Pedro and the weapon possession, was Sergeant Johnson, and his testimony had some problems too. Remember, this is 4 a.m. in the dark. Sergeant Johnson is driving down Broadway. It all kind of turns on his ability to observe this one arm swinging motion that kind of occurs in a split second. We don't even know what lane he was in, and he's at least 130 feet away. And what's interesting is, at trial, he claimed that he was actually 40 feet away, and that's a big difference. That's not just like a minor misstep. And I think it's fair to infer that he was exaggerating his proximity and his ability to
But
view
the
these
jury
events.
heard that, and they found their verdict in the way that they did. If we were to now second guess that, are we judging the credibility of that witness, and is that appropriate at this point?
You know, I think normally, obviously, this court does defer to the jury's determinations, and that's kind of the default. But here we have such a messy record with so many problems.
Oh, but you know, criminal trials are filled with messy records.
Well, no,
it is
that-
the nature of life, right? So
Right.
life is not
I know.
neat and, right? So criminal trials as a result, and civil trials for that matter, have their share of messiness.
But
So
believe it or
that
not-
by itself isn't
Sure.
enough, and as my colleague said, the jury had an opportunity to hear about all of this and had the benefit of, I am sure, an extensive cross-examination. So why should we now step into the shoes of the jury?
So I would agree with you. Normally, we defer, but there are cases where the incredibility of the witnesses is apparent from the cold record, and I do think this is one of those unusual cases. We have witnesses, multiple eyewitnesses, making completely contradictory claims that they never really satisfactorily resolved. That's one situation where no amount of demeanor or, you know, intangible observation can really change the fact that the problems are apparent on the record. And as you know, Your Honor, there's a 2-step test. The first step is basically, would an acquittal have been unreasonable? And I think here we clearly passed that hurdle because the jury this was a close case. Like, no doubt, the jury was scrutinizing the evidence, especially as to the counts of conviction, and they rejected a good portion of that evidence when they acquitted.
So why should we disturb that?
Well, because actually, the partial acquittal cuts in favor of weight of the evidence reversal, as this court has held and as other appellate division departments have held, because it shows that exact fact that the jury kind of could have gone either way, and then this court does have the power to make de novo credibility determinations, and I think this is precisely the case where it should be done. It's hard to do justice to exactly how incoherent these witnesses' testimony was.
Counsel?
Honestly.
No.
What you claim are inconsistency, could it be just the translation issues?
Well, the translation was not challenged below, so we have to accept that. I mean, this is the official court interpreter, and his English translation is binding on the jury and binding on all of us on appeal because it wasn't challenged and
Counsel,
presumed correct.
didn't both Pedro and Fernando have ample opportunity to view the defendant during the hours before the assault? They adequately described he was wearing a red hat, a black shirt, and a red or pink knee-length shorts. How is that incoherent? The jury heard what they had to say. Like you said, they scrutinized the evidence based on their assessment of the testimony. They dismissed what they didn't think the people met their burden on, and they found him guilty on what they believed the people did meet their burden on. What's so repugnant about this verdict?
May I respond
Yes.
briefly? In addition to the contradictions in their testimony they identified, I think one really important factor is they're both extremely drunk, and this part doesn't necessarily come out clearly in respondent's brief, but Fernando has 7 drinks, and he calls that not a lot.
And
Well,
how many hours?
it depends on the drinker.
I don't think
But you'll have time on rebuttal. It depends on the drinker. You have 5 minutes.
May it please the court, Claire Lynch for the people.
So you asked that the appeal be dismissed, right?
Yes, we did file a motion to dismiss.
If the court was to come to the conclusion that the conviction should be affirmed, is there reason to apply the fugitive disentitlement doctrine?
Yes, we believe so, Your Honor, and I know that this court did dismiss our motion to dismiss, did deny our motion to dismiss without prejudice, which is why we're making those arguments again today. There's been,
So what would be the reason for applying the doctrine if there was to be an affirmance?
well, there's been no documentation that defendant has been hospitalized or the like, and neither.
Well, what's the point of the doctrine? Isn't the point of the doctrine is why should the court busy itself with deciding the appeal if the fugitive isn't going to listen to the decision of the court anyhow? But if there's an affirmance, there's nothing for the fugitive to listen to. Your conviction stands and things stay the way they are.
Sure, I understand that. I guess defendant was on parole for 2 years, and now for the last 2.5 years, he's been absconded, and for the entirety of this appeal process, actually. And so, you know, he hasn't been compliant with parole. We're not really sure of the reasons for that, but, you know, they're asking for a great remedy here to dismiss, to vacate the conviction, and
But I'm asking you, if we were to affirm the conviction, and isn't there precedent for the idea that if there's an affirmance, the court doesn't apply the doctrine?
I'm sorry, can you ask?
Isn't there precedent in where the conviction is going to be affirmed, that the court doesn't apply the fugitive disentitlement doctrine?
Yes, I guess there is some for that because this is a weight case. However, even if this court does not dismiss defendant's appeal, we do feel that it should affirm his convictions because the evidence at trial overwhelmingly.
Was the intoxication of the witnesses, the civilian witnesses, was that ever addressed, challenged, discussed before the jury?
Yes, this was all aired before the jury. The witnesses testified that they did have several drinks. Again, this was over several hours after a day of work where they're at a restaurant, they're eating food. Again,
6 beers over the course of 2.5 or 3.5 hours.
Yes, I guess
Give or take.
one was about 4 hours, the other was there for 2.5 hours. So this was a long time where they were eating food after their work shifts were completed. And yes, the jury was aware of all of this testimony. And Lieutenant Johnson testified that these witnesses were coherent. He was able to communicate with them through the translating officer at the scene.
And then Johnson himself was a witness to certain events.
Yeah, crucially, we have Lieutenant Johnson here who saw defendant stand in front of Pedro, swing his arm, and hit Pedro across the face.
It was from a significant distance, right?
Well, okay, so at trial, he testified it was 40 to 60 feet away, and I think defense counsel was misconstruing the record because at the grand jury, yes, he testified he was about a half a block away. This was not a case where at the grand jury he testified that he was 125 feet away, and then at trial he changed his testimony to 40 to 60 feet away. He was just approximating. He was about a half a block away. And again, he did see this action happen where Pedro was hit in the face, and that is the crucial distinction here because this could be a reason why the jury did acquit on 4 of those 6 charges. And mass repugnancy or not, this is not a circumstance where the court should second-guess the jury's reasoning here. They could have based their verdict on the witness's testimony, Fernando himself testified that he wasn't really sure who took his phone in the moment. So that could have been a big reason why the jury did not convict on those charges.
And I am correct that when the officers finally reached the complainant, he had a laceration to his face and lip.
Yes, and the jury was able to hear from him about those injuries and also see photographs of those injuries where, yes, he did have stitches above his lip, across his lip, and below. So unless there are any questions, we ask that the court affirm. Thank you.
Thank you.
Just to clarify a couple things about the distance. It's true he didn't say I was 130 feet away. Where I'm getting that from is that is the distance of the average half of a block in Manhattan. I think the jury has a sense of how long that is, and that's certainly something that this court can take notice of. As far as the intoxication, this isn't just based on self-report. The complainants went to the hospital, and even an hour later, when they were examined by doctors, they were both described as like unstable, fall risk, and intoxicated. They were visibly intoxicated. So, we don't have to worry too much about, what they said about their drinking. And lastly, I just want to address the fugitive disentitlement doctrine. The fact that we are requesting the remedy of dismissal is exactly the point, because no matter what this court does, there will be no new mandate that Mr. Jacero has to follow. It's not going to be a reversal and a new trial. He won't have to go before the court again. Either this case goes away and the parole violation goes away, or he still has a parole warrant. And the Supreme Court in Ortega-Rodriguez has said that this type of remedy is an exception to the fugitive disentitlement doctrine.
Thank you. 21st Mortgage Corp. versus Lynn.
May it please the court.
Yes.
Stephen Seltzer for appellant. In this mortgage foreclosure action commenced in 2018, the case, my client moved for summary judgment prior to the enactment of FAPA, was denied summary judgment. Respondent was granted summary judgment under the Engel precedent. In this case, we have a clear acceleration from a 2009 prior foreclosure action commenced, and under Engel, there was a unilateral deceleration by the sending of a letter. Subsequent to the summary judgment motion practice, but prior to the issuance of a judgment of foreclosure and sale, FAPA was enacted, and under FAPA, specifically CPLR 203H.
What date are you using to say prior to the judgment of foreclosure and sale?
Okay.
What date?
There was a judgment issued by the lower court judge on July 12, 2023. Your Honor, that judgment was not entered. It was not signed by the county clerk. It was not stamped by the county clerk, which is required for entry. It never was until it was amended subsequently in September 2023. But FAPA was enacted before the initial judgment pre-amendment, which was never entered, was issued. So under the FAPA, there's no question that the action is untimely under the applicable.
Was that judgment originally attached to the notice of entry?
That judgment was attached to the claim notice of
2022?
entry, was not signed, Judge, was not stamped, and therefore it was a nullity. It came in, issued by the judge, issued on NICEF. The county clerk didn't review it, didn't address it, didn't enter it, and the respondent simply just served it. But it's a nullity. The amended judgment entered September 19, 2023.
So you were served with it. So you were served with it with the notice of entry in 2022.
No, not 2023 of the judgment, but again, that was a nullity, and Baronello and Court of Appeals precedent, Reynolds versus Dustman, all hold that strict compliance with CPLR 5513A is required, and there was nothing close to strict compliance here. In fact, the amended judgment of foreclosure and sale was never served with notice of entry, and appeal could be taken tomorrow on various grounds of the judgment because we did not have strict compliance or any compliance for that matter. But there's not a question that under FAPA this action was commenced untimely. The unilateral deceleration letter does not do it. This court, in numerous settings, has addressed the constitutionality of FAPA, the due process clause.
Did the court below address that issue?
The court below found that notice of entry was timely.
And then it stopped. It didn't get to the FAPA issue, did it?
No, it never got to the FAPA issue. It never got to the application of FAPA.
Would we be able to reach it then if the court did not address it below?
It was argued below, and I would submit that there are no issues of fact here. The facts are undisputed. So based upon a review of this record, I believe the court can do the FAPA analysis. Can do the FAPA analysis. There are no contested facts as to the acceleration and the deceleration of the statute of limitations, and I would submit there's not a substantial question regarding the constitutionality of applying FAPA retroactively here.
So
Yes,
it
Your
was
Honor.
just ministerial actions taken by the clerk of the court?
Well, there was no ministerial action taken by the clerk of the court such that the right to appeal would have.
For the July
the appeal
one.
would have started.
Thank you.
Thank you.
Thank you, Your Honors.
Brewster versus Hunter.
Good afternoon, Your Honors. Michael Confusio for the appellant. I think summary judgment should have been denied squarely on the issue of the question of post-operative care. I really think if you look at the plaintiff's expert report, that's where his report focuses on. The major problem that I have with the way the judge decided the case was that he didn't focus firstly on the post-operative care, in part because I think the defendant's two experts had a lot of their report about whether or not it was proper to choose the particular procedure that the doctor did, the defendant doctor did, and then if he performed.
But one of the defendant's experts did address issues of postoperative care in terms of the blood patch, and indicated that it would have been too soon to perform the blood patch with, I think that's a 1-day time period. Did the doctor, the plaintiff's expert, address that issue? Because I didn't see it inside his report.
He didn't. He addressed the blood patch issue and said that it was part of the standard of care that should have been done once there was.
Yes, but he doesn't controvert the defendant's doctor's expert report where the doctor says that, yes, that is the protocol of care, but you cannot begin it until 3 days after symptoms have begun. And the 2 dates that Dr. Housecanet pointed to were day 1 and day 2. So even if it were true, the protocol was not called for until the day after. So how is that not problematic for you?
Well,
Seeing as Dr. Housecanet neglects to address it at all.
yeah. Well, he does. Oh. I think Your Honor's right in terms of the detail. He doesn't address directly what the defendant's doctor said.
And doesn't our case law require him to?
Well, that's maybe where the case law says that the plaintiff's expert is supposed to address what the defendant's expert's opinions are. I think the problem I have is what is the level of detail by which you have to address it.
I think our case law is replete with what the level of detail that is required.
See, I think, Your Honor, that him saying that given what the symptoms that the plaintiff had, that a reasonable doctor would have had her lie down.
Where in his Dr. Housecanet's report does he directly address the issue of the 3-day
does.
lag in the administration of the only known treatment, which was the blood patch? He
Well-
does not at all address that 3-day requirement.
I agree with Your Honor on that.
Okay.
What I'm saying is
Why is that not fatal then?
I don't think it's fatal, one, because the blood patch treatment is only part of the overall treatment that the plaintiff's expert said should have been done.
No,
Yes, it is.
no.
If you look at the plaintiff's expert.
I looked at all, I have them right in front of me, in fact.
Well, his expert report says what it says, Your Honor, but what I viewed his expert report as saying, and my recall, is that he said, upon her experiencing the numbness in her legs, the dragging of her legs, and the headache, that a reasonably competent doctor would have had her lay down, be hydrated, and receive some kind of pain blockage for the headache, and that should have been done immediately.
So does he explain how the outcome would have been different had this symptomology been recognized earlier?
I think that the plaintiff's expert does talk about that in his expert report. He says the delay, because essentially the plaintiff didn't get any treatment until she went to the emergency room, which I think was on the 2nd of November. It's about
Didn't she get prescribed antibiotics by the doctor?
In the original on October 30th.
And thereafter?
I don't know if she was
She
prescribed.
kept on saying, prescribing more medication, stay with the lotion, which was a medicated lotion, and if anything changes, call me back. And your client didn't call back.
Well, that's where we get, Your Honor, into the problem with the conflict of facts. Here's the issue with the defendant's expert reports. If you look at their expert reports, and I laid this out, I think I'll peach.
Now, let me, because you just said something interesting, the conflict of facts. The case law I'm familiar with on medical malpractice focuses on the differences in the expert opinions, right? And I've already pointed out that your expert utterly fails to address, as our case law requires, the specific opinions of the defendant's experts. Our case law says that is fatal.
On the blood patch, that's not the entirety of the plaintiff's expert's opinion. His opinion isn't singularly whether or not a blood patch should have been administered. It's
He also said analgesics and rest are also part of a treatment.
and laying down, and that it should have been done immediately after these symptoms were noticed in the procedure room. And I know my time is running out, Your Honor, but this is important. If you look even on my page 3 of my main brief, the opinion of the defendant's expert is about the postoperative care. That's all I'm focusing on. I think the only way to reverse the summary judgment is the postoperative care. All of their expert opinion about the validity of postoperative care is based on what Dr. Hunter said occurred. There is a direct conflict between what Dr. Hunter said happened and what my client said in her sworn testimony versus his. And I laid that out in the briefs. If you take their opinion and you say, what happens to your
But then, counsel, you're turning this medical malpractice case into just an issue of credibility between these two witnesses. But we have medical malpractice cases that say more than that. That's why we look at the experts. And what are the experts saying?
But the expert opinion, Your Honor, can only be as strong as the facts which a jury find are true. That's an important facet of the case, in any case.
And facts based on medical records or just hearsay statements of a patient?
Judge, a plaintiff's
All I'm saying is everything that Dr. Houseknecht based his opinion on was based on statements made by your client, none of which were supported by the medical records. But you will have time on rebuttal to address that.
Can I just say one
You
thing?
can address that on rebuttal, sir. Thank you. You have time now. You may proceed.
Thank you, Judge. Good afternoon. My argument doesn't have to be long. In short, we plainly showed the motion court that.
Well, counsel, let me. Your adversary seems to argue that even if Dr. Houseknecht does not address the blood patch issue, there were other issues such as other treatments that could have been taking place, such as lying down and things of that nature. Is that enough, or does he have to directly rebut every single thing that the defendant's expert brings up?
He doesn't necessarily have to rebut every single thing that the defense expert raised, but I think what he did actually affirm is the opposite extreme. He did not affirm that he even read any of either of the defense experts' affirmations. And the case law does require that he address the specific assertions made by the defendants and their reasoning in arriving at those assertions.
Counsel, I have several questions, so bear with me. Your experts assert that the standard of care post-op for a patient is to monitor if they exhibit symptoms like a headache, to rule out anything more serious than standard side effects, i.e. spinal fluid leakage, correct?
Correct.
Where in the record is the monitoring defined? And if it's not defined in the record, how can we know that the standard of care was met here?
Well, I don't know. Monitoring these symptoms, I would think would just be the dictionary definition of monitoring.
So is your client's position that telling the patient to call back if the headache persisted meets the monitoring requirement of standard of care?
Well, the monitoring consisted of her being in the recovery room for about an hour, during which time Dr. Hunter checked up on her multiple times.
And so that's the monitoring in the record that we should.
Correct. And during that time, her symptoms improved, and she testified that she walked out of the office on her own power, walked to her car, and took a cab to her car, and then drove to pick up her daughter. And it wasn't until the next day when she spoke to staff on the phone that she said she had a slight headache, and she was told to call back if she had any newer worsening symptoms, and she did.
And that's monitoring.
Correct. As for the blood patch, I think the court hit the nail on the head there. Our experts said that the standard of care only called for it to be applied if conservative treatment had failed for 3 to 5 days, which didn't happen in this case. She didn't even return to or have any interaction with the office within 3 days of her appointment, within 3 days of the procedure. And she was offered the blood patch and refused it, and her treatment or her symptoms improved anyway. So it was not, according to our experts, indicated at any point. This is something that isn't rebutted specifically by plaintiff's expert. There's also the issue of the lack of a nexus between any injuries that she alleges she suffered and any departures from the standard of care. There is a November 2017, there was imaging of her brain taken in November 2017, which was reviewed by our expert, Dr. Siegel, and he said that nothing in that imaging supported any of her subjective complaints. Dr. Hausknecht doesn't address that finding by Dr. Siegel. It's not rebutted, and
So to be clear, they did find some subdural hemorrhaging going on, but the defendant's expert's opinion was that the degree of the bleeding was not of such a nature that would have caused the kind of symptoms she described, and had she had those symptoms, the physiological findings would have been very different.
exactly right, Your Honor. There's nothing in that imaging to support what symptoms she's claiming that she continues to feel. And I see my time is up.
Thank you.
Briefly.
You have 2 minutes.
Two brief points. Again, I want the court, I would invite the court respectfully to look even at page 8 of my brief. If you look at what the opinion of the defendant's expert is about post-operative care, the entire opinion is premised on what Dr. Hunter said occurred. And getting back to Your Honor's question about, it isn't hearsay for a plaintiff to say, I told the doctor I was having a headache, I was unable to walk, I had numbness, and the fact that it may not be reflected in a medical record certainly could be a credibility issue at a trial. A jury might
She
go,
can, I clearly misspoke, she can clearly testify to that at trial. My point is,
Yeah.
all of the things she said happened, none of it was documented in the medical records. So there was nothing to support that she told the doctors that she had a headache. She claimed to stumble out of the hospital after the procedure. And frankly, I know of no hospital that allows somebody who just had an operative procedure and is stumbling to walk out of their
But
room.
Your Honor, with all due respect.
So all I'm saying is the records don't support her statement.
But Your Honor, that's not the summary judgment standard, and I think that's where we have.
No, I understand that.
Okay.
The
Well, that's what.
standard is the experts.
The standard
And
is-
so we go back to that.
Well, the standard is you have to view the facts, especially in the light most favorable to the plaintiff, not the defendant. His whole expert opinion is premised on what the defendant said. If you look at the brief, you'll see that squarely on post-operative care. The other aspects of the claim are gone. My expert didn't say anything about the procedure itself and all. It's squarely on post-operative care. Even if the damages are minimal, a plaintiff still has a right to go to a jury and have the jury determine what the damages were on that square issue.
Got
Thank
it.
you for
Thank
hearing
you.
the case, Your Honors.
Have a good day. You too, Joe. Thank you again. Thank you. People versus Dantrell, Calderon.
Center for Appellate Litigation by Molly Booth for Mr. Calderon. Your Honors, a mistake of law is not a defense. Mr. Calderon was denied effective counsel who was familiar with the basic elements.
Why wasn't justification charged in this case?
Why wasn't justification? It would seem that Mr. Calderon was in a position of safety. He had an officer squarely between him and a separate area with a door closing in front of him. That's what the court found. I believe that's what the video reflects.
Well, just to follow up on that question, because one of the elements of the charge is intent, for which justification would negate that intent. If the defense counsel was pursuing a strategy of justification, would that be sufficient for us to maybe not hear this motion, this appeal at this time, and have it be heard on a 440 motion, because there is, in fact, some sort of legal strategy going on there? Or is that not enough? I mean, because I read through the jury charge and the conversations that they were having, and it seemed to be that justification was, in fact, the strategy.
Justification was certainly something that defense counsel came into the case hoping or believing he'd be able to raise. But as part of that, he has his client testify and he presents a closing argument.
Let me ask you another question. Was justification a defense in this case?
Was it a defense in this case?
Was it a legitimate defense that could actually fly in this case?
No.
No. There were 2 counts, right?
Yes.
Okay, so he was charged with assaulting with intent the officer, and then assault that could have been through a third party.
Correct.
Correct?
Yes.
So that even if the jury bought justification as to the correction officer, that was not a defense for the strike against the third party, correct?
Correct.
And am I correct that both of those counts are the same level crime?
Yes.
So that it can't even be said that the strategy of counsel was to get a conviction on a lower crime in order to ensure that his client would get a lower sentence.
Correct.
So that wasn't even going to be achieved with this strategy either.
No.
And it seemed apparent from the record that the defense attorney was quite confused because he thought that the transferred intent being argued by the people was a new theory.
Yes, after closing arguments, he
Right,
says,
and-
is that objectionable?
and
And
the-
no one wants their lawyer to ask that to the court after closing argument.
Right, and the court said, I don't understand. Did you read the jury charge?
It's in the statute.
Subsection 7 says to a third party. So clearly, there's nothing. Tell me, is there anything in this record, anything that I'm missing, that this justification defense was ever going to help this client?
No.
Thank you.
So you just said the justification wouldn't be a defense if he was seeking to strike the bearded man. Why wouldn't that be a defense if he was striking at the bearded man and he thought that he needed to do that in order to protect himself, and by mistake he struck the officer? Justification would still be a defense to that. He wouldn't be criminally liable for striking the officer if he had legitimately struck at the bearded man and mistakenly ended up hitting the officer.
Well, the jury wasn't entitled.
Would justification be a defense to that?
If they, in facts that are completely different than this case, I imagine it's possible, but here
If
that
that's
he's
what
not
happened,
entitled to the
if
instruction.
that's what happened, justification would be a defense.
If he were entitled to the instruction, if a reasonable
yes,
view of
I
the
mean,
facts would support a justification defense,
The
then
question is, defense counsel tried the case on the theory of, one was that he just struck the officer, but his defense was justification, which at the end the court doesn't charge.
well, he tells the jury,
He opened on that.
he voir dires on it, and at the end of the case, he tells the jury it's these other people who are the bad actors, which I'm not going to disagree with when you look at the full video. And then he says he didn't intend to hit the officer. He didn't intend to hit the officer.
Right, so he's talking about the intent, because intent is an element of 120.05 sub 7, as it is 120.05 sub 3. I mean, they both carry the elements of intent, again, for which justification would negate that intent. And even if you are intending to, you are justified in protecting yourself against an assault, a perceived assault, and the judge doesn't charge it, does it make your strategy bad at that point?
It does when you've made, so let's just assume, I don't agree, but let's assume justification could be a defense in this case. If that is the case, it's still not a reasoned defense. You have not thought about the charge if you don't realize the intent element could allow for conviction if the person
Are you saying
intends to
that
hit a third
justification
party.
can't be a defense for transferred intent?
Well, I'm saying that you have to be aware of whether it is before your opposing party closes. You have to be aware of whether that is
And that just
a
brings
theory
me
of
to-
liability, which he says, I don't know how this client can be convicted under that theory.
But also, just to, I guess, follow up on that point, there was an email that went out before summations that
Yes.
indicated that the people were going to charge transferred intent.
Yes, it starts with the statute that says transferred intent is a theory of conviction. The CJA includes transferred intent, which the court alerts defense counsel for, another shocking
The
thing.
people's original theory of the case was that the defendant intentionally struck the officer.
Yes, and then defense counsel walks into a transferred intent theory blindly because he was unfamiliar
Because the
with its
people
potential
changed their
applicability.
the people changed their theory.
Yes. I mean, I think any reasonable
I'm not saying
prosecutor
they
would
didn't-
change their theory.
I'm not saying they didn't have a right to, but that's how this developed.
But they had charged it in the indictment, so it was a part of the indictment.
Yes.
And
there
then when we say change the theory, it's a brand new charge it doesn't appear in the indictment. That is not this case.
No. And also,
There was a
Your Honors, it's
consolidation
like
motion,
if you're-
counsel, there was a
Pardon?
consolidation motion that also consolidated, there was 120.05.3 and 120.05.7. So there were two opportunities then to understand that transferred intent was one of the people's theories.
yes, and
And he missed it.
he missed it. He just
clearly missed it.
You read before you go to trial on this, and it might be misleading. It's otherwise looks like a misdemeanor charge.
He missed
but
it. He
it's a
puts him
fun-
on the stand and he gives it to them.
Yes, he gave them that theory, and the people were understandably happy
But if he
to
was
argue to the jury that that's
if he
a
was
theory.
to pursue the justification defense, what else could he do but to adopt the position that he was striking towards? He can't come in and say that the defendant sought to punch the officer. Clearly, he's guilty. His only defense to get out of this case entirely was to say that he was striking at the bearded man which he had justification for, and he mistakenly struck the officer. What else was he to do?
Before you answer that question, am I right that the jury had seen the video?
Yes, the jury saw the video.
So that nothing, this defense lawyer could have sat down throughout the entire trial, let the video play, and on summation argued what they wanted.
Correct.
They could have argued justification. You could tell from the video he didn't want to hit the correction. He could have argued all of that without having an admission by his client on the stand
Yeah,
from the trial.
understanding the intent element is something you need to know from day one of the indictment with how you position the entire case, including.
Counsel, am I
Whether or not
mistaken?
he admitted, whether or not he admitted that he struck the officer, the video showed that he struck the officer.
But it's not the striking the officer admission that's the problem. It's saying, I meant to hit this other person. Otherwise, you could go up on summation, you could say, listen, my client was caught up in the
But he
moment,
meant
he
to
would have
hit
hit
the
a
other
wall at
person.
that point,
He
doesn't
meant to
know.
hit the other person in defense, right? Or did he say
He said
that
a
he
sucker
sucker
punch.
punched him? Right?
so-
Is that justification?
That can never be justification. And yet, he's
Counsel, am I-
arguing to the jury, listen to what my client said. He didn't intend to hit this officer. And then you go cut to client, and client said this was a sucker punch.
Counsel,
tried to.
am I correct that defense counsel also misstated the elements of the penal law to the jury?
Yes.
You'll have time on rebuttal.
Good afternoon, may it please the court, Faith Petrolio for the people.
So counsel, I guess my opening question for you would be, you've just heard all of the issues and whether or not there's a strategy or false strategy or whatever the case may be. Should a 440 motion have been filed in that case based upon this record where clearly maybe there was no strategy?
Well, Your Honor, I believe that there should have been a CPL 440-10 motion in this case. I think that would have given us an opportunity to understand the actual strategy counsel is putting forward, not the ones that we can, speculate on based on the record. It also would give us.
Is it speculation?
Yeah, it's not speculation.
I mean,
It says it outright on the record.
Sure. We can also, if from a 440, would be able to tell counsel's, thought process behind making those decisions, and also his understanding of the law, as well as conversations that he might have had with defendant about whether to accept a plea.
Can we
whether
all
to justify.
agree that he clearly did not understand that the 07, the sub 07 charge was a transferred intent charge? Can we agree based on the record here? I mean, the judge says so, right? So we know that. That's not even an issue here, right? So I mean, that's a problem, right? Because that is like a central part of what becomes the people's theory, and allowedly so, since you indicted on the count. There was nothing nefarious about your arguments, right?
If I could just respond to
Yes.
that. To Justice Friedman's point, I believe the justification defense that defense counsel was attempting to put on would actually have applied in that situation.
To what? To which
To
charge?
a third party, to the
But he
strike
said that
How?
he was behind the door and he said that I wanted to get one last hit in, so I sucker punched him. Is that justification?
Well, Your Honor, I think if,
Counsel, on what earth would that be justification? I sucker punched him. That is like the definition of intent.
I take your point, Your Honor, but defendant also testified that he was in fear for his life. He feared for his safety because these other inmates were coming at him. Brian, the officer, also testified that the inmates would not retreat. They wouldn't step back even after being ordered to do so. They were getting in Brian's face, which is why he stepped in between them. So I think it is a reasonable argument to make to the jury
Counsel, how is this different from People v. Holland? Why do we need a 440 when it's clear on the record that he made egregious error?
I would argue that it's not clear on the record.
So it's not like People v. Holland?
I would say that in this case, it's not exactly clear, at least in my reading of the record, that counsel was fully unaware of all of these things that you were discussing with counsel. I would argue that.
You hear the point of some of my colleagues that he's just admitted that he didn't know the law of transferred intent. What's your response to that?
I would argue that he didn't actually say that he didn't understand the concept of transfer intent. I would say that yes, he missed the email, but he came before the jury instruction was actually given, and he objected to the instruction being given, and he said, and he came prepared. He had case law, he used the correct definition, he said, this doesn't apply in this case. And I think it's...
So he just didn't notice the 07 on the indictment?
Well, Your Honor,
I mean, because I can't get past that.
I understand, Your Honor. But I think the people had been, using their theory of the case in terms of that defendant was angry at Brian for getting in his way, and that's why they hit him. And I think he was, responding to that. Whether or not that was a good strategy, he did have a strategy, and he stuck to the strategy.
See, my understanding of justification in New York is that you are required to retreat if you can do so. If you have other means of protection, he had a court officer in front of him, a correction officer, forgive me, right?
Yes.
So,
I understand, Your Honor.
and again, I don't see how, even if one can say that would have been a justification as to hitting the officer, I don't see how it's a justification for hitting the guy who's beyond the officer.
What I would say to that, Your Honor, is that he did have a strategy. It was a reasonable one given the difficult evidence that was before him. He attempted to make the argument. That it was not successful does not mean that he's ineffective.
He only has strategy for one count, counsel.
Yeah.
It's clear. He was clueless. He's like, oh my God, they changed their theory. Did he even read the indictment?
I would argue that none of that is part of the record. There's no 440 motion in this case. We don't know what exactly he was looking at, what exactly he was.
The record, the judge even says, counsel, had you read it, you would know.
But that's what
He says on the record, I'm sorry, it was a little crazy. I didn't see that email. I wasn't, what email on transfer intent?
But yes, he didn't see the email, but he also, comes back before the jury instruction is actually given in an attempt to hopefully stop it from being given. And there's nothing on the record that said.
But summations had already been done by that time. And when the judge mentioned, I think it's like page 81 of that particular jury charge, the numbers roll in error, but the judge there was a series of questions. You sent an email to the court. I see that you sent it to defense counsel. I'm going to charge transferred intent. And then defense counsel says nothing. They just go right into summations.
He says he was distracted. He was talking to his client. He didn't hear that. It was a very, very brief discussion.
And you also acknowledge that defense counsel misstated the elements of the penal law to the jury.
My memory doesn't serve me for that, Your Honor.
Okay.
Thank you.
Thank you.
Defense counsel had a strategy uninformed by the penal law, and that's not having effective counseled representation.
So my question, we've had this big discussion. Is this a situation where we sent it back for a 440 motion or not?
No, this is very unusual where you have a defense attorney saying, I missed the email. The email reflects what's in a pretty straightforward statute. He says, I missed the on-the-record discussion of this charge, of this, and
Counsel, his strategy was based upon a misunderstanding of the penal law, correct?
Yes.
And we know this because he misquoted it to the jury, yes or no?
Yes.
Why didn't you make a 440 motion?
Because the record here is straightforward and clear, and had I made a 440 motion, it would have taken Mr. Calderon another year before, if I was successful, for the indictment to be back, or I would have to get leave to be back here, and we would see, I guess. But no, that's what informed our strategy, was because the defense counsel seemed, on the record, was uninformed or surprised by a very straightforward theory of conviction that would have and should have informed his trial strategy from the moment he received the indictment. And that was reflected both in his client's testimony, allowing your client to get up on the stand to present that defense, and then pointing the jury to that testimony, when this case had, in a 5-minute video, would have shown everyone some real risks with going forward that way.
Thank you.
Thank you.
Okay. Zane versus Isacson. Justice Rosado is recused on the case. Should there be a tie amongst the justices, we will pursue our AD1 procedure. You may proceed, counsel.
Good afternoon. May it please the court. Megan Lawless, counsel for the defendant appellants, Dr. Ernest Isacson and his professional corporation. The question for this court on appeal is whether Dr. Isacson may invoke New York's COVID-19 immunity statute, the EDTPA, for healthcare services rendered under emergency conditions at the height of the COVID-19 pandemic in New York City.
Under the public health law, was Dr. Isacson considered a healthcare professional under the EDPTPA?
Well, that's the question before this court. So we're not asking.
Well, I mean, was it enumerated inside the statute?
Yeah, so it was not, so there's two sections at play. So Dr. Isacson does not contest that as a podiatric surgeon, he was not one of the medical professions within subsection 4A of Public Health Law 3081. But further down in the definition of healthcare professional, there is subsection 4E, which defines that term as someone providing healthcare services within the scope of authority permitted by a COVID-19 emergency rule.
Well, I mean, it's a little bit more detailed than that. It says means services provided by a healthcare facility or healthcare professional, regardless of location where those services are provided that relate to, and all of the relate to COVID-19, maybe symptoms, diagnosis, treatment, or is it something more than that?
I'm sorry, which subsection, Your Honor? I was just quoting the definition of healthcare professional.
Okay, I'm reading from 3081. I think you cite this in your brief under subsection F.
Yeah, so the definition of a healthcare professional that's entitled to immunity under the EDTPA is 3081 section 4, and under that is A through F. So we're contending that it is subsection E that brings Dr. Isacson within the scope of the statute, because even though he's not one of the professions enumerated in A, based on the circumstances and the type of care provided in this case during the time frame and the fact that it was telehealth, because this patient was a suspected COVID-19 patient at the time, that it brings him within the authority of using telehealth.
Does it matter that podiatrists have had the ability to use telehealth even prior to COVID-19?
Under the facts of this case, I don't think so, because again, that goes to COVID-19 emergency rule. We disagree that that term should be so narrowly defined as.
But they were allowed to use telehealth before.
Correct.
Only the April 8th appointment is something new which falls under the COVID regulations.
Correct. April 8th was different because it was a telephone call.
That's the only one that's clearly within the new COVID regulations, which would fall within that healthcare provision you just read before.
Correct. That's the executive order that expanded the use of modalities for telehealth. But our contention is that the term emergency rule, it's not defined in the EDTPA. It's not capitalized. It should not be restricted to simply the specific verbiage of a single executive order. I would ask this court to look at the federal and the state emergency directives in effect at that time, and also look at the motivation behind these telehealth visits. This was not pre-COVID, it's more convenient to have a visit via telehealth. This was post-COVID. The reason these telehealth appointments happened was because this doctor's office was mainly closed. The patient in this case was suspected COVID-19 on both days that he saw the doctor. And the mandates from the federal government and the state of New York were stop the spread of COVID. The CDC specifically said in a very detailed
Yes, but you're asking us to now consider news directives, CDC, health mandates that they gave every other month, as opposed to the legislation that was put into effect for our state on handling the providing of healthcare here?
Well, the multi-level. So the executive orders speak to specific circumstances, but that
when does a court do that? We have a statute, we follow the statute, we enforce the statute or not?
Correct.
We don't go outside and say there were other opinions being bantied about on the issue.
No,
So
but
I'm not sure I understand what other sources outside of the statute that we have to analyze and decide whether this falls into it or not.
Well, the statute does not define what is an emergency rule here. Are we confined to the specific section of one executive order that just talked about now phone calls are allowed when they otherwise weren't? And I think also, in terms of the rules of statutory construction and the freedom.
Correct me if I'm wrong, but following up on what Judge Mansonet says, it sounds like you don't fall within the terms of the statute or the regulations, but what you're saying is, look, this was clearly a COVID-related examination, and therefore we should apply the immunity provision to these visits.
Well, I think it's a matter of, this is emergency conditions and the motivation of the doctor. Why did this doctor see this patient via telehealth? It was because of COVID. What was the state telling us to do, telling the medical professions at that time to do? Do not see your patients in person. If you can any way help it, use telehealth. So I think that needs to be kept in mind when you're looking at the definition of subsection E. Emergency rule, what does that mean? Does it apply here? If you look at all of the public health authorities and what they were saying at that time, they were all saying the same thing, and that was reduce the risk, contain the disease, socially distance, do not see your patients in person if you don't have to.
And where your state has enacted a statute, follow it. But we'll hear you on rebuttal.
May it please the court, Jonathan Ratchick from the law firm of Kramer, Dunleavy, and Ratchick.
I mean, I would observe that as you look at this, it's hard to understand why podiatrist and a podiatric surgeon wasn't included among those enumerated. I mean, clearly it would seem it's a medical type of service. It's hard to understand it.
I can't speak for what or why Albany, when they rushed this statute through and enacted it, did not include podiatrists, but the statute is very clear, and it enumerates by license number those professions who were included and upon whom the statute conferred immunity. And podiatrists were not included among them.
But
in
subsection E, it references, I mean, it's kind of broad with providing healthcare services within the scope of authority permitted by a COVID-19 emergency rule. How does that exclude podiatrists? Because that's a separate section.
Sure. So twofold. Before one even gets to that, well, that goes to the question of whether or not the defendant, appellant, was a healthcare professional as defined by the statute. And if the court takes a 30,000-foot view of what the statute was designed to do, it was to confer immunity upon those professionals who were essentially deputized by the state of New York to fight in its fight against the pandemic. So there were a lot of out-of-state physicians and nurses who the state during the pandemic said, it's okay if you're not licensed in New York, you can help save lives here.
Right.
That's what this is speaking to. And
Can we agree that during the pandemic, part of the emergency was not just treating, I mean, in the beginning, it was just people dying, right? So we were dealing with COVID in a really severe way, but then it turned to other medical services that are required by the public are not being met. And so I think part of the reason for this statute was to make it easier to provide services for people who could no longer go to their, skin doctor or whatever it was, right? So now my question to you is this, following up with my colleague here on this subsection E. Mm-hmm. His treatment with this doctor, it's not like he went to the foot doctor for a bunion, right?
It was not.
He had a deep laceration to his heel. The man had comorbidities that created a medical problem, and here a severe one, right? So why doesn't his treatment, at a certain point when his patient, now it's not just a podiatry problem, but now we're talking about a systemic body problem that could be fatal, right? He lost his limb as a result of it, right? So why doesn't at that point his service become one that falls within a medical professional? He's giving him antibiotics, he's doing all of the protocol for this type of treatment that he would have gotten had he gone into an emergency room, which was not being allowed at the time because we had too many COVID patients.
Except when he ultimately did go to the emergency room, he was on death's doorstep. So not sending him to the emergency room when he has all these significant comorbidities, which were life-threatening for him, was a gross departure from the standard of care. But to address Your Honor's
an
question-
issue for summary judgment.
right?
To address Your Honor's question, that's why one has to look at how does the statute define a COVID-19 emergency rule? Because it enumerates those exceptions which are regarding scope of practice. And that's what I spoke to earlier when it talked about other physicians and nurses and professionals who are not licensed in the state of New York, or when it talks about delivery of care. And as Your Honor picked up on, in the state of New York, since you can always render telehealth services even before the pandemic. You could always call up your doctor or your podiatrist or your optometrist, whomever it might be, by telephone and discuss
Right,
your
but
care.
I'm sure you will agree with me that there's no question here that this particular doctor was being compliant with the executive orders. Don't have more people in your office than you need. If you can do telehealth instead of in-person, that's preferable. So,
Well, I think that's where we
right?
disagree.
Huh?
That's where we disagree, because if one
You can continue.
reading the
Go ahead.
statute, which should be narrowly construed when they confer immunity, because the statute, they already know that the statute was too broad, which is why they revised it in July or August of that year and ultimately repealed it in its entirety the year after. But it's all about within the scope of authority. So it has to, and that's the operative word, authority. Was this authorized? Of course it was authorized before the pandemic. This wasn't new authority that the defendant was using to treat Mr. Zane. He already had the authority. There were no regulations or policy statements or whatnot that newly enabled the defendant to treat Mr. Zane in this manner. He could always do it. And that's the distinction, and that's where their argument falls flat.
And that's the point
because
of
they
having
can
given
never-
immunity.
I'm sorry?
That's the point of having given an immunity.
If you fall within the definition of a healthcare
Of
provider.
something new, if you're doing something new because of COVID.
Which
so
they
you
were
got
not.
immunity.
Which they were not. And that's why.
That's your argument.
I'm sorry?
That's your argument.
That is my argument, Your Honor. And that is why, when they've had 2 years now in which to identify any regulation which newly authorized them to provide either telehealth or telephone or whatever new services they're claiming, they can't do it. And the reason they can't do it is because it doesn't exist. Because there were no new rules that were modified by Governor then Cuomo's executive order that newly enabled them to provide these types of services to his patients.
Got it. Thank you.
Thank you, Your Honor.
Okay, and you have 2 minutes.
Briefly, Your Honor. So we're not asking this court to rewrite the statute or interpret something in it that is against the verbiage. Yes, immunity statutes are to be narrowly construed, but in 3080, the intent of this statute is broad protection for the enormous, quote, enormous response required for this pandemic. And in our reply
If you're
brief,
doing something which you had previously not been authorized to do, and you're doing it because of COVID.
well, that's the question. You know, again, emergency rule, it's not defined. Are we limiting it to rulemaking and the specific terms of the executive order? I don't think you have to look at the statute that way. In our reply brief, we cite a recent Second Department decision, Sapienza. It was not a frontline ED doctor in a hospital. It was a gastroenterologist who the Second Department affirmed immunity because in the spring of 2020, he could not see a patient in person and complications developed. It was a gastroenterologist in his medical practice. This is a podiatrist in his medical practice. It involves office closure and telehealth. We would ask for you to look at the intent of the EDTPA, the broad protections it was meant to confer, and interpret it reasonably. You know, the Court of Appeals says, do not look at the literal terms of the statute in a way that's going to produce an absurd result. There are a number of decisions in this case, state and the Second Department, that have conferred immunity involving skin ulcer care. It involved telehealth care. And I think to not allow Dr. Isacson in this case, when, as you said, he was following the rules, what was the intent? Why did he hold these via telehealth? It was because of COVID. And I think it's patently unfair to not allow him to invoke this immunity before the trial court in the future.
Thank you.
Thank you.
Stikeman, Elliot LLP versus OL Private Counsel. Please wait for my colleague to get back.
Of course.
Good afternoon. I respectfully request that my colleague, Mr. Mortensen, be permitted to participate in this appeal.
Sure. This is a Pro Hoc Vici application?
Correct. He's been admitted pro vice.
It is accepted and granted. You're welcome. Okay.
May I?
You may proceed.
Thank you. Good afternoon.
Good afternoon.
Owners. Greg Laufer on behalf of the appellant. This is a simple appeal. The entire basis, the sole basis, the exclusive basis of the motion court's order denying a motion to quash a non-party subpoena directed to a Canadian law firm was that the subpoena supposedly sought documents relevant to OLPC's supposed counterclaim in the underlying action coming out of Utah. OLPC has now conceded, and it is not disputed, that it never had such a counterclaim. It never existed. And in fact, OLCP just last year in Utah made a motion seeking to add a counterclaim, and then just 2 or 3 weeks ago in Utah withdrew that motion. And so there has never been a counterclaim that OLPC has pursued against anybody in Utah in this lawsuit. So the counterclaim that the trial court relied on exclusively obviously cannot form the basis for denying the motion to quash. That was it.
Were
Yes,
there
Your Honor.
any affirmative defenses to that action?
There are affirmative defenses in Utah raised by the defendants, OLPC and Thomas Olson, against the claims that Ephraim Olson has asserted. But those affirmative defenses were not raised as issues before the motion court as a reason to seek the documents or to support the subpoena. The only argument for relevancy that OLPC pursued in the motion court related to the supposed counterclaim that it had never asserted and that the motion court found existed, even though now OLPC now admits it never had. So those and even if you look, so first of all, the argument is waived, even though OLPC has now tried to raise those affirmative defenses as a basis for proving relevancy now. It's waived because it was never argued below, but even if you put that aside, they don't even explain, OLPC don't even explain how or why documents reflecting communications between Ephraim Olson and any of his family members or friends relating to the law firm in Utah that his father owned and operated have anything to do, for example, with an unclean hands affirmative defense or any of the other affirmative defenses that were asserted by OLPC in Utah. All you have to do is read the affirmative defenses and you'll see that they're totally irrelevant to those documents that are being sought. OLPC says that it doesn't matter, that the subpoena is okay as long as it seeks documents from but relevant to somebody's claims. That actually makes no sense. OLPC faults us for not citing cases. We have cited cases. We've cited cases from the Court of Appeals, including Society of Plastics and Mental Health Legal Services. Those cases very clearly say when you're talking about a litigant pursuing relief in court that it actually has to have standing. Of course, that's a fundamental principle of our legal system. And if I just may finish quickly, the fact of the matter is the only person or thing or entity that asserted a counterclaim in the underlying Utah action was Thomas Olson, and the documents that are at issue, as admitted by OLPC, reflect concerned only Thomas, not OLPC. So for all those reasons, we would ask the court to reverse the motion court's order and grant our motion to quash the subpoena.
Thank you.
Thank you.
Thank you. If it please the court, David Mortensen appearing on behalf of respondent. The issue before the court is whether the motion court abused its discretion in finding that the subpoena sought documents that were utterly irrelevant. The subpoena did not seek documents that were utterly irrelevant to the issues in this litigation, where those documents are relevant to issues pending the litigation including defenses asserted by OLPC. And before the court were the following facts. OLPC is a defendant in the Utah action. Its employee, Ephraim Olson, while working as an attorney for OLPC and while representing its managing member in a divorce proceeding, misappropriated those documents, delivered those confidential documents to his mother and his siblings, who then took those documents and used those in various lawsuits against OLPC and its managing member, Thomas Olson, in litigation, causing severe harm to OLPC and Thomas Olson.
Counsel, so even though the documents pertain to Mr. Thomas, they also affect the interest of the firm.
That is absolutely correct. They absolutely affect the interest of the firm, which is why we've asserted multiple affirmative defenses that make very clear that the defense to his wage claim and his breach of contract claim is that while working for OLPC, he was taking documents that OLPC and its client were using, emailing them to himself, his personal account, and then providing them to opposing counsel in the case. He was literally acting as a double agent, misappropriating documents and serving them, and
Has
that's
unfaithful
the entire
servant
basis. I'm sorry?
theory been asserted?
I'm sorry?
Has the unfaithful servant theory been asserted?
The prior breach and unclean hands theory have been asserted, yes. We don't use the exact words unfaithful servant in the state of Utah. That's just not a legal doctrine that's being used there, Your Honor.
Okay.
But frankly, I'll be honest, I've never heard of that doctrine before, so I don't assume it's...
It's when you assert a wage claim and your employer says, I owe you nothing because you were an unfaithful servant and you did something wrong in your employment.
We absolutely have asserted that very legal defense in different words, Your Honor.
So if that is, in essence, the defense that has been asserted, then it would seem that these documents are absolutely relevant and necessary to not just Thomas, but to the firm.
That's absolutely correct, Your Honor. The documents are absolutely relevant to all of these very issues. And I know my time's getting close. In the Foreman versus Henkin case, the Supreme Court made the New York Court of Appeals made very clear the following. We have emphasized that the words material and necessary are to be interpreted liberally to require disclosure upon request of any facts bearing upon the controversy. These documents, as the court found, unquestionably bear upon the controversy at issue, and therefore they are not utterly irrelevant. Thank you.
Thank you.
Thank you, Your Honors. Very briefly, we are not here to discuss the merits of what is going on in Utah. I understand that my adversary likes talking about whatever was supposedly misappropriated or not. That has nothing to do with this appeal. What this appeal is about is legal.
Well, for us to determine whether the subpoena is utterly irrelevant and not worthy of being pursued, this discussion is relevant.
There's no
We
question.
get to decide what that is.
And I'm simply making my argument, Your Honor. I take your point.
No problem.
The question that was put by my adversary just now was whether it was an abuse of discretion or not for the motion court not to grant our motion to quash. It absolutely was. The motion court very specifically said this is relevant to the counterclaims asserted by OLPC, and all you have to do is look at the brief that OLPC actually submitted below, falsely stating that, as alleged in the counterclaim, and quote, the heart of OLPC's counterclaim is, et cetera, et cetera. None of that was true. And so, to Your Honor's point before, affecting the, if I may finish?
Yes.
Affecting the interest of another party is not the standard under the CPLR. It's not the standard under Capone and other Court of Appeals cases. The question is whether Thomas had an obligation to pursue the subpoena and the documents himself, and if you look at the affirmative defenses, they actually do not bear on the communications that are being sought by OLPC here.
Thank you.
Thank you.
Samsung Electronics versus MPEG. You may proceed.
Thank you, and good afternoon, Your Honors. May it please the Court, Garrett Beeney for Appellant. Your Honors, when all parties to the contract at issue here voted in 2024, 25-0, to ratify their prior act, which had been held to be ineffective because of the way they agreed to.
Was it held to be ineffective? I think that's a generous way of putting it.
Yeah.
Is that what did this court say about it in 2025?
That it was appropriate to find that they had agreed improperly in the way they counted their vote. That was the limit of the issue with respect to the 2020 vote to amend their agreement. It was only that they had agreed to count those not voting as being in favor. The commercial division found that that was not permitted by the contract, and this court affirmed. That was the limit of what the original decision was.
Wasn't it
Does that give
void?
you an opportunity to do a do-over then and change your vote?
I'm sorry, Your Honor?
Does that give you an opportunity to do a do-over and have a new vote retroactive to the prior date?
The new vote was not retroactive. The new vote, consistent with cases like 19 Pond, Board of Managers of Soho, Hoyt, Jane, New York and Security Trust, all allow a body to provide the authority that was missing.
But wasn't, I'm sorry, back in, when this court heard the appeal, and didn't this court say that there wasn't, agree with the trial court rather, that there wasn't a supermajority, which is what was needed to change this kind of?
No, Your Honor.
No?
No. No, the
Okay.
limit of the commercial division's December 2023 decision, and this court's affirmance of that, was only that the licensors, the parties to the contract, had agreed to count silence as being a vote in favor of the amendment.
Accordingly, the court correctly determined that the amendment did not have the number of votes required to pass. What does that mean?
But only because of the count. There's no dispute that there was an 80% vote in favor. It's a question of whether those.
If you don't have enough number of votes to pass a vote, does that not make the vote void or invalid?
No, Your Honor, and in fact, the commercial division held that this was a voidable act, and Samsung has abandoned its cross appeal of that issue. So this case comes to this court with that issue having been decided. The commercial division decided that this was a voidable act. The only reason the original 2020 vote was cast aside, if you will, or not enforced, if you will, was because of the way they decided to count their votes. All parties to the contract reached an agreement that that's the way that they would count their vote. And what the issue there in the commercial division's December 2023 decision, and this court's affirmance of that, was that you could not count someone not voting as being a vote in favor. That was the limit of the reason.
Which meant you didn't have the votes necessary for the vote.
Well, you did have the votes necessary, but you counted them.
No. Okay. You continue with your argument. You're reading the decision in the way that you are reading it. I'm just letting you know that's not how we see it, but please continue.
All right, well, Your Honor, the fact I think that we can agree on is that there was a missing authority in 2020 when the original vote. I think respectfully, if you go back and read the decision of the commercial division, you'll find it was because of the way they
But to get to the
counted.
bottom line, you counted in 2020, you counted silence as a yes vote, and the court said that's not going to fly.
Exactly, Your Honor. So there was missing.
That means that you didn't have the votes.
Exactly correct as to the counting of the votes. It was missing authority, but it's the same situation.
What's the difference about the counting? It's whether you win or you lost. And in 2020, you lost.
Well, but it's the same issue, Your Honors, in all of the ratification cases that come out of this court as well as in the Court of Appeals. So, for example, if you take 19 Pond, there was a defective email vote to exercise a purchase option. This court found that could be, the Second Department found that vote could be ratified by the permitted in-person voting. It's the same kind of situation here. In Board of Managers of Soho Green.
This is not a matter of ratification. This is a matter of actually casting and counting votes. Do you have the 80%? Do you have the 75% yes votes that you needed?
Well, they had the votes, they just didn't count them in the correct manner. So the authority for that original act was missing, very much as this court's decision in Board of Managers of Soho Green. There was a defective vote to support building repairs because the board had taken that vote, so they didn't have the vote, but that could be ratified by the shareholders later on. The same with Hoyt, the New York Court of Appeals case. There was a transfer of security that was ineffective because it was done by officers. The board could ratify it. It's the same
But you
situation.
didn't have the votes here. You didn't have the supermajority of the 80%. That's what the trial court said. That's a little different from the cases that you're citing.
It's not that we're changing any substantive issue, Your Honor. The voting was the same in the two votes. It's not a substantive issue. It's a procedural defect in the way that the process was carried out, if you will, like shareholders making a decision, not a board, or a manager making a decision, not the board of the organization. All of those cases that we cite, and some of the ones that I've cited in argument, are all cases that stand for the proposition that there was an ineffective vote in the original action.
So you're saying the second vote, you're saying that the second vote, all of the people who weren't present and who were counted as a yes were present and voted yes?
There was a slight change in the composition of the members of what is called the administrative committee of parties to the contract. But in the original vote, the parties overlapped considerably to the second vote. And when they counted the vote in 2024, the way the commercial division suggested they should, that vote was 25 to nothing.
Overlapped or were equal to?
I'm sorry, Your Honor?
Overlapped or were equal to? Because I think those are two different things.
No, they were the same. They were the same with the exception of 2 or 3 parties. They were exactly the same parties in the two votes. The same corporations represented in this group of people. And
So the answer to my question is yes, at the second vote, they were present and they voted themselves.
Yes, with the exception of a couple of differences between parties that were parties to the contract in 2020 versus parties to the contract in 2024. There was not a complete exact mirror overlap. I think there may have been a difference of 3, if I'm remembering, Your Honor.
All right, you'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court, William Adams for Samsung. There's absolutely nothing in New York law that permits the do-over that the MPEG and the licensors orchestrated here.
How do you read this court's 2025 decision?
I think this court held 3 key things in its February 2025 decision. First, it held that our position that a vote in section 6.1 of the AAL unambiguously means an affirmative vote. That's what's required under the contract. This court secondly held that the Supreme Court correctly determined that the amendment did not have the number of votes required to pass. And third, that meant that the amendment could not reduce Samsung's royalties. So in 2020, there was a proposed amendment, and that's all it was. It didn't receive the votes that this court and affirming the Supreme Court held were required for that amendment to become effective. There was an absence of sufficient consent, sufficient assent, and therefore, as Supreme Court ruled on this motion, it did not properly come into effect.
The cases that your adversary cites to seems to suggest, well, he seems to suggest rather that this court has held that in the past, and I think there's a distinction between the things that he's trying to, correlate to what's going on here. How do you view that?
No, in the prior decisions, he's trying to put a procedural deficiency label on this. This is a substantive defect. There was a lack of assent. There was no binding contract, and New York courts.
Our penultimate statement in 2025 was, accordingly, the court correctly determined that the amendment did not have the number of votes required to pass.
That's absolutely correct. It did not have the number of votes because there was not the sufficient number of votes that were cast in favor of it. They are relying on the silence, which this court has held is not permissible under the contract, and we don't have any indication that those silent licensors assented in 2020 to the amendment. And so the vote and the ultimate amendment was a nullity. It didn't bind anyone. It had no force and effect, and therefore, under New York law, could not be ratified going backwards. I mean, ultimately, MPEG has no limiting principle here. They want to hold this amendment in their back pocket. They can come up with any basis for some sort of procedural defect, then come up years later when the composition of the licensing of the administrative committee has changed, and they think things are more favorable to them. Then push that vote through, not prospectively. Now, we have problems with the prospective aspect. That's on a different appeal. It's not before your honors now. They want to do it retrospectively, too. And that's just not permissible as a matter of New York law. The amendment was void in 2020. You can't ratify a void amendment. But what my friend actually didn't even talk about was the actual ruling of Supreme Court below. Like what we've been talking about. The voidness is an absolute independent basis to affirm, and we fully embrace that. It's in our brief. There was no need for a cross appeal. What actually Supreme Court ruled was that the ratification was ineffective as to Samsung because it destroyed or diminished its intervening rights to payment. The contract is clear in Section 6.3.2 that royalties must be paid on a quarterly basis. Those royalties became due in between the period of the initial vote in 2020 and the ratification in 2024. And it's very clear under New York law, as applied by the Second Circuit in the case such as Pape, in the New York Court of Appeals decision in Goldschmidt, that you cannot destroy the intervening rights of non-ratifying parties. Here, at time one, there was a group of licensors that purported to have passed the amendment. At time two, a different group of licensors purported to ratify the amendment. In between, there was all these royalties that became due and owing to Samsung. Supreme Court said you can't destroy those rights and wipe them out. So for either of the two reasons that I've just provided, as well as the others in our brief, we respectfully ask the court to affirm.
Thank you. Okay. I'm going to give you his extra 28 seconds, go ahead.
We'll rush through this as much as I can, Your Honor. Your Honor, this case comes to this court with the commercial division deciding that the original 2023 vote was voidable, and that's at R255, incorporated into the decision at R7 in the record. Samsung initially sought to appeal that, and then they abandoned it. So that is waived. This was a voidable act. There is no substantive right of any party to this contract that was impacted by the original vote. There's no doubt that this is what the parties to the contract wanted to accomplish. And if I may just very briefly, as to the grounds that were actually raised by the commercial division in the case as it comes to this court, those were grounds that Samsung never raised. As the court itself recognized at R259 of the record, it was an argument that the commercial division itself raised, and it was wrong for at least 4 reasons. First, the provision of the contract that the commercial division cited doesn't even apply to Samsung, as the commercial division itself recognized, because Samsung ceased being a licensor, as that term is used in the contracts, when it terminated. The section of the contract that the commercial division cited, 6.3.2, only applies to licensors. Second, even if it did apply to a licensor, it didn't give Samsung any right to any specific allocation of royalties. And in fact, Samsung signed on to an agreement that allowed the parties to amend that allocation, which they did. Third, as this court has ruled, and as the Court of Appeals ruled in Civil Service Bar and Blank and Cecil Corporation, no party acquires a right to that original judgment while it remains pending appeal, as that December 2023 decision about the vote counting remains pending appeal. Samsung had no intervening right. So as to the grounds in which the case actually comes to this court that the commercial division relied on, one, it was not something that Samsung ever raised, and two, was incorrect as a matter of law because of the reasons that I've referred to.
You're not suggesting that this court can't address the grounds upon which the court made its decision, whether the other side raised it or not, are you?
No, Your Honor, absolutely not. I wouldn't suggest that at all, but I would, if I may continue, just urge this court To go back to the original decision about the 2023 vote, it was vote counting. It had nothing to do.
Trust me, we're going to go over that.
Well, it
No
had nothing
worries.
to do with any substantive rights of any party to the contract at all. It was voidable and therefore could be ratified.
So your revote is the basis for your motion to renew.
Yes, Your Honor.
Thank you.
Thank you.
Thank you.
And last but not least, People v. Alfred McCrae.
Good afternoon, Naila Siddiqui for Alfred McCrae. Mr. McCrae was sentenced to an additional 30-day jail term, a consequence imposed for not appearing at 9:30 in the morning. This condition to appear at 9:30 was not an explicit term of the plea agreement. And the prosecution concedes that this was not an explicit, but only an implicit condition on the condition that he returned.
I think the judge was pretty clear. Said, you be here at 9:30, not 9:31, not 9:32. You be here at 9:30 or the deal is off.
That
the judge was real clear.
That was after. It was a condition that was imposed after the.
So you're saying that after a plea is entered, a judge can't order a litigant who has just entered a plea to be in her courtroom or his courtroom at the time that the courtroom opens?
If the judge were to add new conditions, the judge would be required to.
The court can order that at any time. It doesn't have to be a condition of the plea.
No, but what happened here was the court enhanced the sentence. If the court wanted to enhance, the court could have remanded, could have sentenced him in absentia, but the court could not have enhanced the sentence because there were only 3 conditions that were specific and explicit, and the consequences of those conditions were that she could enhance the sentence. One of those conditions was not 9:30. The court could, yes, explicitly say after you must be here at 9:30. But the court cannot, that's not a condition of the plea, which if he violated any of the conditions of the plea agreement could be subject to a sentencing enhancement. And the law is very clear.
Okay, well, doesn't the law also say that this is moot since the time has already been served?
No, the law doesn't say that, but this goes because this is not an excessive sentence claim. This is going to fundamental fairness and integrity of the plea because courts, while they can add additional conditions and allow litigants to withdraw their plea, they cannot add conditions and then punish them without giving them first notice.
Defendant didn't move to withdraw his plea. Defendant didn't move to withdraw his plea.
But that opportunity wasn't given to him. When he showed up, he was remanded and sentenced. And the judge also pronounced sentence.
What do you mean it wasn't good? At the time it happened, his attorney could have said, well, Judge, that's what you're doing.
His attorney wasn't present. She remanded him when he showed
Then
up.
it came back on with an attorney present, right?
Well, it was adjourned for that, and then that's when
At
they
that
added
point,
the 30
at that point, the attorney could have said, well, if that's what you're doing, Judge, we want the plea back.
But the judge should not be able to do this because it's not a valid condition.
Fine, but that doesn't change the fact that the attorney had an opportunity to make a motion to withdraw or to ask for an adjournment to file papers to file a motion to withdraw.
But the attorney did let the court know that Mr. McCrae did show up on time, not on time,
Not
did
on
show up
time.
to court, not on time, but did show up to sentencing.
Well, the judge knew that because the judge put the defendant in jail, so the attorney wasn't telling the judge something the judge.
No, but that was the condition that was satisfied. And in fact, one of the conditions that wasn't satisfied, which the judge could have enhanced the sentence for but did not, was that he missed the probation appointments because he lost his paper.
Not once, but twice, right?
Yes, but the judge could have, under those conditions, could have enhanced the sentence, but did not, and chose to pronounce the sentence of 3 years when he came in for sentencing and let him stay out to figure out the child care issues. When he came back to step in, that's when she enhanced the sentence because he was not there and that was an abuse of discretion. It was arbitrary and capricious because that was not explained to him.
Okay.
Yes, the request.
You see that red light? You way over. You'll have time on rebuttal, okay? But I love your passion.
Good afternoon, Your Honors.
Go ahead.
But for the people. Thank you, Honor. Your Honors, as to the merits, the judge certainly was entitled to impose an enhanced sentence because the judge.
When you enhance the sentence, though, don't you have to inform the defendant of what needs to occur before you enhance their sentence. Like, you just can't arbitrarily say, well, I'm gonna give you 30 days. Like, when someone takes a plea, they're notified of the conditions of their release to come back for the plea, and usually it's the 3 conditions: dealing with probation, don't get in trouble, things of that nature. But then what happened here is, even though the judge was quite lenient, allowing time for the person to wrap up their affairs, when they came back late, that was a separate reason other than what was told at the time of the plea.
Sure, Your Honor. But when he first appeared and asked for the adjournment, he essentially renegotiated the plea agreement. He asked for an adjournment, and the judge said yes, under the condition that you show up at 9:30 and not 9:31, 9:32, et cetera, and it explained that if the defendant did not, he said he would enhance the sentence. He said the deal will be off. You just saw what I did to this guy who showed up late. That's what will happen. And he turned to counsel and said, if he doesn't show up on time, I'm going to max him out, just so you know. And the defendant agreed to that. So the defendant asked for the adjournment, and the court added this condition that he appear on time in exchange for letting him stay out, and the defendant agreed to it. So there was a perfectly proper enhancement there. So again, that's the merits, Your Honors, that there was nothing improper about enhancing it. As to the mootness issue, Your Honors, this court held in People v. Moore, as many other appellate courts have held, that a challenge to an enhancement of a sentence is moot when the sentence has already been served. Now, the defendant argues that doesn't apply to his case because he's challenging the integrity of a plea, but that's typically what a sentence enhancement challenge is. The argument is that I wasn't warned that my sentence could be enhanced, or that wasn't a condition that was part of the plea, something that goes to the plea, to the integrity of it. So this is nothing special. This is a sentence enhancement challenge that this court has held as moot. As the defendants claim that, well, this is different because the remedy that I'm asking for here is vacature of the plea. A defendant's not entitled to that. A defendant would be entitled, in a sentence enhancement case, if it's done improperly, to a remand where the sentencing court could simply impose the original promised sentence. Or, if the court insisted on the enhanced sentence, then it would have to give the defendant a right to withdraw the plea. But in either case, the integrity of the plea is preserved. The difference between these two remedies is simply the enhanced sentence or the original sentence. And when the defendant has served the original sentence, that distinction is academic. So again, this is moot. The defendant also isn't entitled to any relief here because the only remedy he wants to accept is one he's not entitled to. He wants dismissal of the indictment. In People v. Consacao, the Court of Appeals refused to dismiss the indictment for a misdemeanor drug possession case where the defendant got 3 days of community service. Here's a Class B drug felony. The defendant negotiated a plea of 3 years. He was exposed to 12 years. It's far too serious to dismiss. The defendant wants dismissal or affirmance. She should get affirmance.
Thank you.
With respect to, well, first, what the court could have done is forfeited his bail if he did not. But the sentence enhancement was specific to specific conditions that were agreed upon at the time of the plea. The 9:30 was at the end of before the appearance, at the end of the appearance, please come in at 9:30 because it takes a long time to process people for upstate. It was a request, not a condition where he was subject to.
Was it a renegotiation of the plea as your adversary?
It was not. It was not. It was not a renegotiation. It was a request. And Mr. McCrae showing up late was disrespectful, as his attorney did say when she was seeking the original sentence.
Did he also request an adjournment?
He did request an adjournment, and the judge did.
Did the court say, okay, but you better be here on time? I mean, I read the transcript. Not a minute.
And
not
the judge.
9:31, not 9:32. I mean, he was clear.
Yeah, and the judge did also forfeit the bail, which would have been allowed, and she returned the bail amount. And for coming late, forfeiture of the bail or proceeding in absentia would have been appropriate. It's the sentence enhancement that's at issue, because that was not a specific part of the negotiated plea. And with respect to vacature would be a remedy. However, because he already completed the sentence, vacature would do more harm because he would then have a new conviction date that would go into his more recent predicate sentencing. The additional he wouldn't have the benefit of new sealing statute that have been recently passed, and he would not, and also the 30 days tolling that he was done, or 30 days additional sentence goes to tolling, and so that is harm to him. And so vacature here, because he's already done this sentence, because it was an observation sale, and he's already been punished. He had 3 years of incarceration and 3 years of post-release supervision. dismissal of the indictment is already, is what's appropriate. And this court has dismissed an assault to conviction.
Aaron, you staying here? You gonna lock it up? Okay.